There it is. Good morning, everybody. My name is Judge Bonnie Rangel. I'm the judge of the 171st Judicial District Court. It is my honor and pleasure to serve as presiding judge. Today's date is, I don't have my little spiel. I'm going to have to do it. Wing it. I don't know where my little script is. Oh, it's down there. That's okay. It is 9:01 a.m., 6/23/2020. We are in the midst of a COVID pandemic, and the Texas Supreme Court has allowed Texas courts to proceed via Zoom and YouTube Live. Mr. Baeza, Ms. Flores, if indeed you have any objections to that, could you tell me right now verbally, Mr. Baeza, do you have any objection to proceeding?
No objections, Your Honor.
And Ms. Flores, do you have any objection?
No objections, Judge.
Very well. With that being said, we will go ahead and continue. I just want to tell everyone participating, there's not very many of us, it's just a motion for summary judgment, that no one is to record this proceeding at all. Any publication of this proceeding, you could be held in contempt of court. My court coordinator is present, as well as Joanna Costa, that is my court clerk. If you want to chat, if you want to utilize the chat, there's no reason to, there's no client, so I don't even need to go into that. You need to ask my permission. Okay, we're going to proceed. This is a motion for summary judgment, and I think this is your motion. Mr.
Yes.
Baez, Ms. Flores, I'm sorry.
Yes, Judge.
So you may proceed.
Yes, Your Honor. I represent J. Ramco Inc., DBA La Victoria Adult Daycare Center. We filed our motion for summary judgment, and that is what the basis of this hearing is for today, Your Honor. In the motion, I'm just going to, quickly summarize it. Basically, the grounds of summary judgment, Your Honor, are based on the fact that the statute of limitations in this case has run, and therefore plaintiff's claims are barred. The federal courts follow the TCHRA, which is a Texas Commission on Human Rights Act, because the EEOC is also involved in this case. And with that, the Texas legislature intended to correlate state law with federal, and the courts interpret the TCHRA as consistent with federal law. Therefore, in this case, the plaintiff only received a EEOC notice of a right to sue based on state law claims. The EEOC has a 90-day statute of limitations. However, since the state courts follow federal courts as it pertains to this issue, the 60-day statute of limitations for the TCHRA therefore would apply in this case. Plaintiff filed her claims more than almost 2 years after she received a notice of a right to sue, Your Honor. Additionally, even if the court were to decide that the 60 days does not apply, state law does held or show that the plaintiff must file and serve the defendant within the 2-year statute of limitations. Here, the correct defendant, J. Ramco Inc., DBA La Victoria Adult Daycare Center, was not served until November. Additionally, the original petition or amended petition was not filed against J. Ramco until November, which is 2 years after.
Give me substantiation. Generally, you file a lawsuit within the 2-year statute or 4-year statute, then you utilize due diligence to serve. So it doesn't necessarily have to be within the 2 years. Where are you getting that from, Ms. Flores? That it has to be in the 2 years.
Your Honor, that is correct. So you have to file and serve within 2 years unless due diligence is established. However, under Fedis v. Efford, once the defendant shows service occurred after statute of limitations, which it's undisputed in this case that J. Ramco Inc. was served after limitations, the burden then shifts to the plaintiff to explain the delay in service. Now, plaintiff in their response to the motion provided a list of, I guess, the public records that show that, and she argued that Marta Ramirez, who's the owner of M. Ramco, had some sort of notice. However, if the information and the plaintiff in this case, Ms. Monica Flores, knew that La Victoria, she worked for La Victoria number 9 and La Victoria number 10, those are all under J. Ramco Inc., Your Honor. So their plaintiff has not provided any sort of evidence to show why there was a delay in service or why there would be an incorrect service of the proper defendant. Additionally, plaintiff also mentions that it's important to note that the M. Ramco never mentioned who the proper defendant was. However, under the law, there is no, I guess, case law that shows that the correct defendant is under an obligation to say, hey, this is a correct defendant. The only obligation an incorrect defendant has is just to say that they're the incorrect defendant. I hope that answers your question, Your Honor.
Yes, ma'am. But I think it was only a 12-day delay, though, wasn't it? A 12-day delay or something like that in serving Ramco?
So there was over a month delay. Well, actually, the initial petition was served or was filed September the 12th, which was a day before the 2 years ran. Then service citation was served after, I guess, on September 23rd. Also, Your Honor, it's important to note that when you're serving a corporation, the person that signed for the certificate of service wasn't an agent of the company, wasn't the vice president or president of the corporation. And then plaintiff filed an amended petition.
Who did they serve? I thought they served Marta Ramirez.
The person that signed for the citation was a secretary. She wasn't an agent. She's not an officer. She's not anybody involved with binding the corporation in any sort. Then in November 11th, and then subsequently November, I guess a couple days after that, J. Ramco Inc. was then served, which was after the
November 11th?
November 11th, the amended petition was filed, Your Honor.
Okay. And then when was the appropriate Ramco served? J or M? I don't know who the appropriate Ramco is. I get confused.
November 21st, Your Honor.
No, who was served? J or M Ramco?
J. Ramco was served on November 21st, again with the same secretary signing the certificate of service.
Okay. J. Ramco and M. Ramco, that's a bit confusing. Very confusing.
So in the evidence that plaintiff provided in their response, Your Honor, there was a very detailed information that is public. And so M. Ramco operates under a different type of, there's a primary home care, which is a different type of license than an adult daycare center. And then the adult daycare center that M. Ramco owns is in Dallas, Texas. It's not in El Paso. Additionally, plaintiff provided documentation from the public records that J. Ramco owns all the La Victoria adult daycare centers in El Paso, Texas, including the 2 adult daycare centers that the plaintiff, Monica Flores, in this case, worked for. So plaintiff, in its response to my motion for summary judgment, like I cited in that case, Bettis v. Effort, the burden shifts to them to explain the delay and to explain why initially the correct defendant wasn't served.
Because it's confusing. That's why. It's very confusing. Anyway, go ahead.
Additionally, Your Honor, in addition to the statute of limitations, I also included in my motion that the relation back doctrine does not apply whenever a new party is added. In this case, plaintiff in his response was arguing that the petition should relate back to the original date of filing, which is September the 12th. However, since a new party was added, actually 3 new parties were added initially, 2 individuals and then the proper defendant, J. Ramco Inc. The 2 individuals, I discussed with opposing counsel, two individuals also were not proper parties.
They're the owners of J Ramco and M Ramco.
Correct, but
Hey.
they are shielded from liability, Your Honor. Therefore, Your Honor, I'm asking that the courts look to the holding the plaintiff to the 60-day statute of limitations in this case. The plaintiff in his response relies on a case, Jones v. Grinnell Corporation. And if you read that case, there's no issue of fact that the 60-day statute of limitations period bars plaintiff's recovery, and the relation back doctrine should not apply in this case because a new party was added, Your Honor, and plaintiff has not shown any evidence explaining the delay in service.
Thank you, Ms. Flores. Mr. Baeza, your turn. Talk to me, sir.
Thank you, Your Honor. First, in regards to the standard of review, I must note that it's the defendant's responsibility to conclusively negate any relevant tolling doctrines here that the plaintiff has asserted. That includes the equitable tolling doctrine that we talked about in the Hilland rule, and that includes the equitable tolling doctrine in the Hilland rule that talks about confusing corporate makeup and due diligence of service. So that being said, in order to, first we need to determine what is the right statute of limitations, because defendant has stated there's three possibilities: the 60-day, the 2 years from the date of charge, or the 2 years from the notice of the lawsuit. Texas law and federal law is pretty clear on this. It's a 2-year statute of limitation under TECRA from the date that the charge is signed. And in plaintiff's response, we provided an appendix with a chronological list of the timeline of events. And the first EOC charge, which was dual filed, that's dual filed means there's a work sharing agreement between Texas Workforce Commission and the EOC. So you file with one, you file with both.
Your timeline, tell me again, is Exhibit 1 in your response?
It'll be Appendix A right before the exhibit list.
Oh, right. Oh, let me get it so I can follow you. Yeah, because I saw that last night. Okay, Appendix, got it.
So the EOC and the Texas Workforce Commission have this dual filing relationship. It's called a work sharing agreement. And what the courts have said that means is you file with one, you file with both. You just have to note on the EOC charge, I'm also filing with the Texas Workforce Commission Civil Rights Division. On each and every EOC charge here, that has been done. So that has been satisfied. Now, once a complainant files that initial charge, then both the EOC and the Workforce Commission have jurisdiction. So there's no issue there. So now we get into the discussion, okay, is it the 60 years? Because the statute does say if you get a right to sue from the Workforce Commission, 60 days.
Got
If you get a right to sue from the EOC for federal claims, 90 days. However, there's this interplay where since EOC does the investigation, most employees or plaintiffs only receive one right to sue, and that is from the EOC, the actual investigatory agency. So the court, including the El Paso Court of Appeals in El Paso County versus Kelly, this is on page 7 of plaintiff's response, has said that the complainant may request that the Texas Workforce Commission provide a written notice of the right to sue. That's for the Texas claims. But there's no requirement that this request be made to do so as a jurisdictional prerequisite. In other words, you can ask, but you don't need it, okay? And in order, the Texas Labor Code, that's section 21254, that statute of limitations, the 60-day statute of limitations is explicit. Within 60 days after the date of the receipt of the notice of right to file a civil action from the Texas Workforce Commission, that is the SOL. However, in Jones versus Grinnell Corp, it says a right to sue notice issued by the EOC is not interchangeable with the notice issued by the Texas Workforce Commission. In other words, in Ledesma versus Allstate, another case from the Dallas Court of Appeals, the plaintiff there only received an EOC notice and then filed claims under TECRA. And the appellate court reversed the trial court's dismissal of plaintiff's TECRA's claims, holding that a right to sue letter issued by the EOC does not trigger the 60-day period SOL. It does not trigger it. You don't have to ask for it, and it's not triggered until you get it. The only requirement is that you wait 181 days. On the 181st day, you can file your Texas claims with or without. And as long as you file it within 2 years, that's Texas Labor Code section 21.256. The statute of limitations for filing a suit under TECRA is 2 years from the date of the charge of discrimination. That is the rule. That's the statute of limitations, 2 years. So now that we know that Texas law says it's 2 years under TECRA if you didn't receive a right to sue, now we can go about this case and figuring out, is there any equitable tolling doctrine? Because there's no question as to whether the lawsuit, the original petition, was filed within 2 years. According to the appendix, the lawsuit was filed September 12th, 2019, the day before the statute of limitations. Agreed, filed against MRAMCO. Why did we file against MRAMCO? Because if you look at the affidavit, that's the first exhibit of Ms. Flores. She knew Martha Ramirez as her owner. She knew Martha Ramirez as the person she talked to regarding her disability. And she had no idea what MRAMCO was. She had no idea what JRAMCO was. So according to her and all the documents between the EOC, Martha Ramirez was the person in question. And when you look for Martha Ramirez and La Victoria, you find MRAMCO, period. That's what you find. You find, and then in the documentation, in the exhibits, we have provided, defense counsel was right, we provided some relevant information as to who MRAMCO is. And when you look at MRAMCO, the owners are Jaime and Marta. The registered agent is Marta. Everything is Jaime and Marta, but it's MRAMCO. And it's related specifically to these, and that's exhibit number 9. Exhibit number 9 is the MRAMCO information. And MRAMCO uses a trade style, 2 trade styles, not only the primary home care, but it also uses a La Victoria Adult Daycare Center number 12. Mind you, there's many center numbers. JRAMCO has various number 1, number 2, number 3, number 4. They skip number 12 for some reason. Nowhere, and in this document, exhibit number 9, you see that La Victoria Adult Daycare, the trade name that's under JRAMCO, and both Marta Ramirez and MRAMCO is related to all these La Victorias.
Where do you see that? Where do you say that? Where do you see that on exhibit 9?
Exhibit 9. So the first page on exhibit 9 is the MRAMCO, the franchise tax. Second page is the owners.
Page.
And then the third page, there's a list.
I
and
didn't
it
know
all
the third page. Go ahead.
And it all relates back to McAllen, Texas, where the owners reside. There, and it has up there the trade name, business record, La Victoria Adult Daycare Center number 12, La Victoria Primary Home Care, trade style, MRAMCO primary, domain name, lavictoriaadultdaycare.com. Right, they're all the same. The phone number is, they're all the same. It's all the same information, because if you go to exhibit number 13, this is the JRAMCO information. And exhibit number 13, JRAMCO information, looks nearly identical. JRAMCO Inc., McAllen, same registered agent. Second page, same owners, Jaime and Marta, same place, McAllen, Texas. And then the third page is this business report. Okay, this is not public record. This is a business report we received after the fact. And if you look at JRAMCO, he falls under numerous La Victoria daycares, 10, 11, 2, 4, 5, 6, 7, 8, 9, not the one cited in the MRAMCO, but look at the information. It's all McAllen, Texas. The principles are all the same. other businesses at the address, they all relate to each other. And this is gonna be important when it comes to the Highland rule that says, hey, we understand that this corporate makeup that some entities attempt to use is confusing. And so we're going to give some latitude when you mistakenly sue the wrong individual, as long as you sue the right individual later, and the right individual has notice at the time of the original lawsuit, you can relate back. That's equitable tolling. The statute of limitations stops, and then we'll continue. Well, here, if we go to, and I want to jump to the Highland rule, that's page 11 of plaintiff's motion, or plaintiff's response to the motion. First and foremost, equitable tolling applies to TECRA cases. That's Texas law, INRI United States Services Auto Association, okay? Equitable tolling applies. So we can look at this stuff. So the Highland rule therefore applies. The Highland rule talks about this rule made up by the Texas Supreme Court that was later clarified in Flower Bluff. And going to page 12 of plaintiff's response, we're going to look at the rule in the last paragraph. The Highland rule starts off with, the Texas Supreme Court held that the plaintiff should have the opportunity to prove the correct defendant was.
You're on the bottom of the page. You're on the bottom of page 12?
Yes, page 12. Yes, it starts off, it's the paragraph that starts with in continental southern lines.
Okay, got it.
So what the Supreme Court held in 1975 was that a plaintiff should have the opportunity to prove the correct defendant was cognizant of the facts, was not misled, or placed at a disadvantage in obtaining relevant evidence. And we have all that here. In Flower Bluff, the next sentence, the Supreme Court clarified this rule. And what they're saying is, if you have a mistake, the general rule is no equitable tolling, except for in these instances where this corporate makeup is a little confusing. And the Supreme Court clarified the rule and said, here's some elements that we need to look at. One, there's two separate but related entities that use similar trade name. Two, the correct entity had notice of the suit. Three, correct entity was not misled or disadvantaged by the mistake. And then they also utilized the 1984 element that said there must be a business connection or relationship present between the correct defendant and the incorrect defendant. So in order to determine whether this equitable tolling applies, and then therefore the relation back doctrine applies, we need to look at these elements. We need to figure out, do these apply here? And again, going to what you said, Judge, is very confusing. And on page 13, the court has said, the Highland Court said, the rule is rooted in the understandable confusion that occurs when a company does business and holds itself out to the public under a trade name. Even the Supreme Court recognizes that. It's kind of hard sometimes to get the right person, to get the right entity. So on page 13, we start with the elements. Here, J. Ramco Inc. and M. Ramco Inc. are two separate but related entities that use a similar trade name. And we just looked at all the information that shows that. Defense counsel admitted, yes, they're both the owners, Jaime and Marta, but they're two separate. One has a home care and a daycare in Dallas, but J. Ramco only has daycares. That's two separate but related entities that use a similar trade name. I don't think that's a question here, Your Honor. Second, page 14, the second element, J. Ramco Inc., the correct entity, had notice of the suit. And this is in question here. There's a fact question here. And if there's a fact question in this motion for summary judgment, it should be denied. And the fact question is, did J. Ramco have notice of the suit when it was first filed? And the answer.
Let me interrupt you a little bit.
Yes, Your Honor.
I agree with you there, Mr. Baez. A determination if the statute of limitations has run is a legal question.
Okay.
I think it has to be determined as a matter of law. So when something has to be determined as a matter of law, you can't allege there's a disputed material fact, so this summary judgment has to be overruled. I don't think you can do that, can you? Create a material fact in an issue that's a matter of law to be determined?
In order, but the defendant's responsibility here, and it's affirmative defense, is to completely negate every element. And
But-
here,
If it's a matter of law, if it's a question of law for the judge, you can't create a material factual issue. I've got to decide what it is, and it's a matter of law. I decided and I rule. Right?
as a matter of law, yes.
Okay. And this is a matter of law, whether the statute of limitations is run. I don't think you can create a material factual issue regarding the facts that substantiate or don't substantiate the running of the statute or the tolling of the statute. I don't think so, unless you give me case law that you can create a material factual issue in matters that are determined that are matters of the law.
Okay. That being the case,
ahead.
even that being the case here, it's very clear that J. Ramco or Jaime Ramirez or the other owner, Martha Ramirez, had notice of the suit when it was filed. It's pretty clear here. If we look at the appendix, first of all, back in April, when the first EOC charge was filed, Miss Martha Ramirez had notice. This was 2 years prior. How do we know she had notice? She had notice of the charge and the right to sue, because the right to sue was sent to Martha Ramirez. And if she's going to say she's not a part of J. Ramco, everything shows she is a part. And it was admitted here, they're both the owners. So did J. Ramco have notice? Well, when M. Ramco was sued, they were served within 10 days later by the registered agent, Martha Ramirez, who's also the registered agent of J. Ramco, who's also the owner of J. Ramco. She received notice. And it's important to note here, the MSJ isn't about whether service was properly done. The MSJ is about whether the 60-day or the 2-year was done. Right. It's very specific here. There's no argument about, hey, you failed to serve. How do we know we served? Because M. Ramco filed their original answer. They were served on September 23rd. 4 days later, answer filed by M. Ramco / Martha Ramirez / the owner Jaime Ramirez by the same attorneys that represent both companies. Now, for them to say that they had no notice of this lawsuit, that's just disingenuous. They had notice. They had notice. It's very clear they had notice. Then going to the diligently serve, because the defendant has said, well, if you don't serve within the statute of limitations, it doesn't count. That's not true. The case law is very clear. As long as you can show diligence, it counts, relates back to the original filing. And here, filing the lawsuit September 12th and serving them by September 23rd, that is 10 days. I think it's clear that that's diligently served. And we served them via certified mail return receipt to their registered agent who received it, or at the place of business received it, and then an answer was filed. Then we get notice in the MSJ and the petition that, hey, you filed against the wrong individual. So we had to, and the reason I pointed out that the correct entity wasn't named was to give an explanation as to why it took about 45 days to figure out who to serve, because it's confusing. So in the end, we served J. Ramco, Jaime Ramirez, we served everyone we could think of to make sure we get the right person. And we successfully served them within another 12, 13 days. And they received that because they filed an answer December 2nd. We served them November 21st. We served J. Ramco specifically September 21st, and J. Ramco answered 12/2 with the same attorney. Element number 2 of this Highland rule is clear. They received notice. So going on to element number 3, page 15, J. Ramco was not misled or disadvantaged by the mistake. There's been no allegation by the defendant that they were misled or disadvantaged. They received the same notice at the original filing, and they received a lawsuit within 2 months. There's no disadvantage there. There's been no allegation that there's a disadvantage, and that's a requirement under the elements in regards to this Highland rule and equitable tolling. So we believe that that's not shown, therefore the motion should be denied. Number 4, a business connection or relationship is present between J. Ramco and M. Ramco. I think we beat that. We've done enough to talk about whether there's an actual relationship. I mean, the defense counsel said they're both owners, same owners for both companies. So, and then finally, plaintiff must show that they exercise due diligence, and the dates, the appendix, the timeline shows due diligence. Why did it take a month, 2 months to file against J. Ramco? Because we needed to find out who we're supposed to sue. So we sued everybody. And then properly, we non-suited the owners because we were told in a disclosure, hey, the correct entity is J. Ramco. We're trying to do all the right things. We're trying to sue the right people. This corporate makeup makes it a little difficult, but that's the point of the Highland rule. So for those reasons, Your Honor, I believe that the motion for summary judgment should be denied. And even if, Your Honor, in the alternative, you think, oh, wait, no, we shouldn't deny it. There's 2 charges of discrimination. The first charge was for active discrimination while employed. The second charge was for a wrongful termination, including the same disability discrimination, harassment, but then they finally fired her. And we filed that charge in June of 2018, which means June 21st, 2018, which means the statute of limitations on that one just passed. And we very clearly had an answer by then. But I don't think that should be the case. I think the Highland rule applies, equitable tolling applies, relation back applies, and the entire case should survive, Your Honor.
Thank you. Thank you,
Thank
Mr. Ms. Flores, you want to respond?
Yes, Your Honor, just very quick. My first point is that the relation back doctrine does not apply when a new party is added. That's very clear by the case law. Number 2, plaintiff wants to say that the correct defendant, or Marta Ramirez in this case, had notice back in April. However, the receipt of an EEOC notice of a right to sue is not indicative that a civil lawsuit will be filed, especially when the EEOC stated that they did not find in their investigation any violations of any statutes or laws. So no, it's not fair or reasonable to assume that the correct defendant had notice back in April that a civil action was going to be filed. Third, Your Honor, and my last point is that the Texas Labor Code section 21.254 states that yes, within 60 days of notice of a right to sue is received, a civil action may be brought. However, notice in this case, for argument's sake, can mean EEOC, the notice of right to sue, since plaintiff, although plaintiff did state at the very top of both charges that the Texas Workforce Commission Civil Rights Division and EEOC, there is case law, Your Honor, that at the very bottom of both charges, and you will see there's a box that was not checked off by her that said that she wanted this charge filed with both the EEOC and the state or local agency. Including Texas Workforce at the very top, this doesn't satisfy the fact that the EEOC, additionally, the plaintiff has not provided any evidence that the EEOC forwarded this complaint to Texas Workforce. Yes, there is a work sharing agreement. However, for argument's sake, we can reasonably assume that since the EEOC was the one that investigated this claim and they did issue a notice of right to sue under the Texas Labor Code, within the 60 days, notice of right to sue is received, a civil action may be brought. Therefore, I'm asking that the court grant the motion for summary judgment and rule that the 60-day statute of limitations applies. Additionally, the relation back doctrine does not apply when a new party is added, Your Honor.
Okay, Mr. Baez, anything else? I allow you guys to argue until you don't have anything else to tell me. So I'll allow you back again if you want to, Ms. Flores. Mr. Baez, anything else?
No, I just think it's very clear that it's 2 years. The state law, the law is stated in plaintiff's response, Your Honor.
Okay. And Ms. Flores, nothing else?
No, Your Honor, nothing further.
Okay, very well. I'm going to go ahead and deny your motion for summary judgment, Ms. Flores.
Yes, Your Honor.
What else? Now, this is what I'm going to tell you guys. You guys need to try to work this case out. You know, we're not going to, as I told you before, we're not going to see a courtroom on any cases, on any jury trials, I don't think this year. If we're lucky, next year, right? So in this particular case, will mediation be appropriate, do you think, right now? Or are you guys so far apart and you're fighting it vehemently and vociferously that you can't settle this case? Or what are you guys thinking?
think with the MSJ, we haven't really discussed that, but I think mediation is always appropriate and would be willing to go to mediation on this issue.
What do you think, Ms. Flores? Why don't we do mediation right now before has extensive discovery been done yet or not? Because you just got.
I respond to discovery and I've received plaintiff's responses yet, Judge.
Okay. I saw some responses to something in the system by plaintiffs, I think. Responses to, were they interrogatories? Is that what they were, Mr. Baisa? Just June 8th.
I
June the 8th.
believe there were responses filed.
Yeah, did you, and you didn't get them, Ms. Flores?
No, Your Honor, when, do you know when?
June the 8th. June the 8th is when it was, I saw it in the system last night, June the 8th. Mr. Baisa, did you send them to Ms. Flores?
I will verify, Your Honor. Usually we e-file, but
You did e-file because I saw it in the system.
so usually that goes, but I'll make sure. I'll make sure.
Okay, Ms. Baisa, check the e-filing because it's in the system as of June the 8th.
On June the 8th, Your Honor, was the defendant's responses to interrogatories.
Maybe I'm confused then. Then I'm confused.
They
Okay.
may not be.
Yes, because I haven't received any discovery responses from plaintiff, Your Honor.
Okay,
We'll figure it out.
okay. Do what you need to do, communicate. Okay, can we agree to a mediator? You want to do mediation? Once written discovery has been exchanged, I think it may be appropriate for a mediation. Can you
I
guys
agree.
agree to mediator and I'll do an order to mediate right now within 60 days or 90 days?
Sure. I can propose Judge Villa,
Ms. Flores,
Anklit, Hardy.
about Via or Ann
I can agree with Mr. Hardy.
Hardy? You want Hardy? Okay.
That works.
Okay. So it'll be Bill Hardy, Ms. Becky, do the order mediation. You want 60, 90 days from today's date? How much time?
90 days, please, just so I can make sure the responses have been sent and then we can
Okay.
set that up.
You got it. You got it. 90 days. Ms. Flores, you're okay with 90 days?
Yes, Your Honor.
Okay. What else, counsel? Anything else?
Nothing further from me, Judge.
Let's try to settle it. Otherwise, it's going to be hanging around for years. Thank you.
All right.
Ms. Flores, take care of your beautiful baby.
I will, Your Honor. Thank you so much. I'll have a good afternoon.
You too.
Thank
Thank
you,
you so much. Mr. Baeza, thank you. You all may be excused.
Thank you.
Hi, Judge, may be excused?
Oh, you know what I forgot, Miss Becky? Yes, Miss Acosta, thank you.
Thank
Miss
you. Have a good day.
You too. Miss Becky, I forgot to tell somebody to do the order denying. All he has to do it, Mr. Baeza.
Call Mr. Baeza.
Tell him to do the order denying, please. What's happening with poor Mr. Lopez?
Judge, Sam has the order. He already sent it to his supervisors and everything. It's PR bond. So I had to call PR. So I asked Alejandra and she says that they do the PR bond interview remote to the annex. But I was looking at, he has like 6 or 7 misdemeanor court cases. And on all his misdemeanor bonds, it says cash or surety. But this is when Ed asked you if that the judge was going to go ahead and go with whatever bonds you give on yours. But we didn't prepare the misdemeanor bonds. Ed was supposed to get the misdemeanor courts to do that and send them to you.
Okay.
And I called the court and then Ed was in a Zoom hearing. So he couldn't answer me, but he was gonna call me back because we were gonna see if he was gonna have that ready.
Yeah, Ed dropped the ball on this one. Ed
Right,
dropped the
so,
ball. I forgot there were misdemeanor cases.
but I told Sam, as long as we do our part and everything, let's do it right now and everything, and then he'll just have to get it, he'll have to get it over there and everything, but I wanna let them know that if they get, the misdemeanor cases, the PR bonds and everything, to send them to Alejandra because she has a misdemeanor, our felony PR bond, so she can handle it all together. I don't know.
Yeah, Ed kind of dropped the ball on this one, really. He should have gotten the ball rolling on all of this when we had the last hearing.
And he should have had those orders prepared and ready.
Gotten misdemeanor.
It's like 6 or 7, Judge, and then they're not even, if they're like, what was I gonna tell you? Some of them are like
Okay,
5,000 or 2,500 surety, you're still putting them on the same PR bond amount?
yes, yes.
Yes? Okay,
This said that the misdemeanor court would go along with whatever I said or did, so I guess everything PR. But Becky, call up Artemio. Tell Artemio to call Chavez and to tell her that she's gonna have to cancel the 20 today at 1 o'clock.
okay, and then I think when Chavez sent you the email right here, it said that she wasn't gonna be in, but that she was gonna follow up or something when she got back on Monday. I don't know if that's Monday coming or,
Let me get out of this system now that I don't have to worry about it, because I don't want to get out of this.
oh yeah, because we're on YouTube Live, Judge.
And
Oh,
also, didn't Artemio say that
he's off Monday and
you
Tuesday.